Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin. I'm coming in from Calgary, Alberta. I'm here to answer your employment law questions today for the next half hour. So, any questions you have about your employment rights, feel free to share them in the chat. I'll be happy to answer your questions as they come in, and we'll be discussing any employment law matters that you have today. So in the news, we've been hearing a lot about the potential for an upcoming recession. We're waiting to hear what the Bank of Canada does with interest rates coming up on Wednesday, whether they'll raise them again. Of course, many economists fear that if the interest rates go up too high, that may tip the Canadian economy into a recession. When you hear recession, you often also hear about job losses, which is kind of an unfortunate situation that some of you might be in or might be in a few months. What's important to remember is that in Canada, you have certain rights when you're terminated. So you have the right, of course, to be terminated with a fair severance. All right. So a fair severance is going to change from person to person. It's decided using a variety of factors. So no two people's severance will necessarily be exactly the same. That said, a fair severance, can be more in the ranges of a month per year rather than a week per year. So if you're getting something that's very small amount of severance, I urge you to contact us, have us review your termination letter, your severance package, and have us look at your employment contract to see if there's anything in there limiting how much severance you're entitled to. It's very important. It can really help you, weather the storm to have a proper severance to hold you over until the economy is back on its feet and until you find new employment. So we have our first question here. Jude Harris, sorry. The question is, it's hard to prove when you know it's from workplace harassing you like 36 years. So I'm not sure I understand your question there, Jude, but I think I get that what you're getting at is that you're the victim of workplace harassment and you're having trouble proving it, which is often the case. All right. So one thing I always tell my clients is when they come and see me, they're being perhaps bullied or harassed by a coworker or by a manager, and I ask them to explain how they're being bullied and harassed, and they might say, "Well, it's not the words themselves; it's how they're said." Right. And what's important to remember is that eventually, if you stand in front of a judge and tell the judge, "Well, my manager was harassing me," the judge might ask you, "Well, how so?" And if you're in a position where you're saying, "Well, you had to be there, judge," well, that's a problem because you have the burden of proving that you've been terminated, proving that you've been harassed, proving that you had a poisonous work environment. And of course, the judge can't be there by your side, seeing, the look, the tone, the body posture, the body language and all of that. So basically, it can be a little bit challenging to prove that you're the victim of workplace harassment if there isn't something in writing, or if you aren't taking contemporaneous notes or addressing the issue with that coworker or your HR department. In many cases, if you feel that you're being treated unfairly, the first step is to contact your HR department and explain to them that you think you're the victim of workplace violence or harassment. Now, in Alberta, Ontario, and BC, there's a requirement that every employer investigates claims of workplace harassment and workplace violence. And if they fail to do that, that in itself might give you some ammunition to claim that you've been the victim of harassment, that you've been constructively dismissed, and that you can go after your severance. So the first step, I think, would be if you're feeling that you're being harassed, what I tell my clients is, keep a journal, write down, you come back home that day, and this something happened at work. You might not see a judge for a couple of years, right? But if you write down exactly what happened, exactly verbatim what was said, what you said, what they said, how it was said, and all of that, then you have a memory prompt for later to explain exactly what happened. Because of course our minds get fuzzy over time, we forget important details, and we might forget a crucial detail that would have helped you be successful in your claim. So yeah, once you feel that you're being pushed out, they're kind of trying to get you to leave by creating a work environment that's not pleasant, that might amount to harassment, start keeping a journal, start keeping notes, try to put as much as possible in writing through emails, etc., so that there's a trace of what's been going on as well. Now we have another question here from Suzette DaCosta. My employer has now said that they likely won't be able to have me return after my maternity leave. What should I do next? I had initially asked for a shift change to accommodate me and was refused. So generally, if you take a maternity leave, you're more or less guaranteed a job when you come back, in the sense that an employer cannot terminate you for having taken a maternity leave. All right. If they do terminate you for having taken a maternity leave, then you have a claim in human rights. You have a claim, of course, for severance, if that's all you want to go after, but you can also get the Ministry of Labor to investigate. If the Ministry of Labor, Human Rights, if they feel that you were terminated because of your maternity leave, they can order that your employer reinstates you. They can order that you be paid back wages. So there's a lot of avenues. When you take a job-protected leave, such as a maternity leave, it's precisely that. Your job is protected. There has to be a job for you to come back to. That said, if you're terminated while you're on maternity leave, but the maternity leave had nothing to do with it, then all you really would be entitled to in that case is severance. Imagine a scenario, a whole department gets terminated and moved to another country, and one of the employees in that department happens to be on maternity leave. So that person will be terminated along with all the other employees, of course, but the termination had nothing to do with her maternity leave. It had something to do with the department being relocated. So in that case, you don't have a guaranteed job to come back to. You're only entitled to severance. So I guess what we need to know a little bit more is why your employer is deciding to terminate you. Is it more a scenario where there's just no job to come back to, or is it, that they've hired a temporary replacement that they want to make permanent, in which case you would have some significant entitlements potentially. So we'd have to get a bit more detail about that. And you mentioned that you asked for a shift change to accommodate, I guess, your childcare needs. So again, speaking of human rights, family status is a protected human right. What that means essentially is if you need an accommodation to account for your family status, then your employer has a duty to accommodate you, all right? And they can't just say, well, this is too hard, we're not going to do it, here's your termination letter. They have to prove that accommodating you would amount to undue hardship. What that means is that, courts expect there to be some hardship that the employer will bear, all right? So if it's a little bit complicated, if it's inconveniencing to them, that's not enough. It has to be an undue hardship, which is a high level of hardship that they can't overcome, all right, for them to be dispensed from having to accommodate you. So again, we'd have to understand a little bit why they're saying they can't accommodate your shift change and what you could do instead to help. Could you, place your child in daycare? Is there someone else at home that can take care of the child while you're at work? Things like that all needs to be explored to have a better understanding of whether your employer needs to accommodate you. Now we have a question here from Facebook from Samantha. Can your employer revoke a vacation if they have already approved it? All right. So essentially, there are some things that what ends up happening is that for vacation, you have right to a certain amount of vacation, but you and your employer have to agree as to when it's taken. Now, I think you would have a claim here if you've been approved for vacation and they're telling you now, well, you can't take it after you've booked your flights and all of that. That can become a complication. That said, the rule is that you would have to get your employer's consent to the time that you get that you get off, essentially. So if you have suffered losses or are going to suffer losses due to trip cancellation, flight cancellation, hotel cancellation, and all of that, you might have a claim against your employer for that, especially if they've already approved your vacation. That said, I've definitely seen it happen where people don't get approved for vacation and instead call in sick on that day or on those days and still go on their vacation. I would advise you not to do that. The people who I've seen do that have come to me because they've been terminated for cause. Now, cause is a hard burden to prove, but you're definitely not helping yourself if you're taking unauthorized vacations either. All right. So do keep that in mind. We have another question on Facebook from Mike. Can my employer require me to work on statutory holidays? So yes, they can. Essentially, it's a little bit like overtime in the sense that if you are required to work on a statutory holiday, then you're entitled to statutory holiday pay. So generally, as you know, if you take a statutory holiday off, you get paid for the whole day. So not only do they have to pay you for the full day, but they have to pay you time and a half for the time that you're working as well. All right. So that can add up to a lot of money potentially. But depending on the terms of your employment contract, for instance, if you have an employment contract that you work Monday to Friday, 9 to 5, and there's a statutory holiday on a Monday that you generally be scheduled to work, and the employer wants you in there, then yes, you would have to go in to work your shift. Absolutely. So there's a lot of kind of intricacies in there that you can find in laws that protect employees and employers called employment standards legislation that deal with a lot of these types of issues. So statutory holiday pay and vacation pay. To return to the vacation pay, if you're not allowed to take your vacation, I know a lot of employees think that if they don't take the vacation, they lose it. So that's a common myth that I hear a lot. What's important to realize about vacation is that you earned that vacation, and if it's not given to you as vacation time, then you're required to be paid that as vacation pay. So a lot of times people will leave a job, either they'll resign or they'll be terminated, and on top of their severance, they get a substantial amount for their vacation that they had accrued but not used up until then. So if ever an employer is telling you, use it or lose it, that's not actually in compliance with the law. When an employer is telling you, well, you have 3 weeks of bank vacation, if you don't use it by the end of the year, you're going to lose it. That's not true. What's going to happen at the end of the year is they're going to have to pay you that vacation time as pay, all right? And you'll get a vacation payment. The other thing that people don't realize is that this vacation pay, they can't hold on to it for years and years and years. That has to be paid to you at some point. Usually it's within 10 months of the year after it's earned. So imagine a scenario, 2022, you earned 3 weeks of vacation. You didn't take a day, all right? You go into 2023, if you're still not using that vacation, then it has to be paid out to you by October. So if you have some accrued vacation from a few years ago, you can require that your employer pay it to you right away, all right? So that you have those extra funds instead of having it sitting dormant in a vacation account where you can't use it. All right? We have another question coming in by email here from Rond. My employer has classified me as a contractor, renewed biannually. How do I know if I'm actually a contractor or an employee? Now, that's a great question. And I get that question a lot because more and more these days, employers are, instead of hiring people as employees, are hiring them as what they call independent contractors. So the reason employers do that is several-fold. So of course, when you're an independent contractor, they don't make deductions for income tax. They don't make deductions for EI premiums, either your share or their share, and they don't make deductions for CPP and either, again, your share or their share. So it's cheaper for the employer. It's easier for the employer to call you a contractor rather than to call you an employee. The challenge, though, is that might be illegal, all right? So there's tests that have been established to decide whether a worker is actually an employee or a contractor. And this is important because there's a series of rights that apply to employees that don't apply to contractors. So if you are an employee, then you have rights to vacation pay that we've been talking about, statutory holiday pay, termination pay, severance. Whole bunch of rights become available to you. You're allowed to claim for EI, you're allowed to access CPP, whole bunch of things of rights become available to you. So courts, when they see someone who's claiming they're an employee and their employer is claiming they're a contractor, they'll ask themselves, well, a contractor is someone who's in business for themselves. So I always use the example of a contractor that comes into your house to renovate your bathroom. So that person is in business for themselves. They aren't working for you. They have 50 clients, whatever it is, and they go from house to house renovating bathrooms. All right. They come to your house with their own tools. You pay them whatever flat rate you agree to. You don't pay them by the hour. And they can hire helpers. They run the contract the way they see fit. All right. Now that's a true independent contractor. It's someone who's in business for themselves. All right. Now imagine a scenario though, that same contractor has a helper. That helper is probably an employee, not of you, the homeowner, but of the contractor. So that employee goes to wherever work site the contractor tells them to. That employee is paid by the hour. The contractor will provide the employee with a uniform, with the tools. There's no real chance of profit or risk of loss. So imagine the contractor quotes you, I don't know, $3,000 to renovate your bathroom. And if he or she is able to do it quickly and not have to pay the employee too many hours, then they have an opportunity to earn profits off the quote that they gave you. If for some reason the job runs long, they might suffer a loss. And that's the markings of a true entrepreneur. An employee gets paid by the hour, no matter how many hours it takes, essentially. So there's no way that they can make more money unless they work more hours, which is the hallmark of an employee. So basically, the question a court is trying to answer for themselves here on is, are you in business for yourself, such as the bathroom renovator, or are you part of somebody else's overall business, such as the employee who's part of the contractor's business? All right. And if you're part of an overall business, then you're an employee. And in that case, as I said before, you're entitled to vacation pay, statutory holiday pay, overtime pay, termination pay, severance, whole host of rights. You can claim EI if you're terminated. You can collect CPP when you retire. A whole host of rights become available to you, and you don't have to deduct your own taxes. You don't have to charge HST, all of that. So, employers classify people as contractors because it helps them simplify their business. It generally does not help the employee to be called a contractor. All right. So if you feel that you're being misclassified as a contractor, I invite you to reach out to us to help you, guide you through the process of getting, organizations such as the Ministry of Labor, the CRA, to classify you as an employee so that you can access your employment rights. All right, so Suzette is following up, Suzette DaCosta. So she's saying that they haven't really said if my position is filled or available. So you'll recall Suzette was the one who's being told she can't return to her old job upon return from maternity leave. So Suzette, I mean, at this point, I think that if you want to pursue your severance entitlements and your human rights entitlements and all of that, the employer has a lot of explaining to do as to why they can't call you back. You can try to do that on your own. I generally tell my clients that you're never going to get your best offer, your employer's best offer, without a lawyer. It's generally not the case in my experience. I suggest you reach out to us. We're always happy to help people who are returning, mothers who are returning from maternity leave and are being, given the runaround by their employer. Reach out to us. We're always happy to talk. We want to hear about what's happening at your workplace, and we want to help fix it. So reach out to us. We'd be very happy to talk some more. Now we have a question coming in from Reddit. Can an employer fire someone for cause for a home cannabis use now that it's legal? All right. So that's an interesting question. And the fact that cannabis is legal is not the end of the inquiry. All right. So there are some workplaces, you can imagine, here in Alberta, the oil fields, heavy machinery, all of that, that are safety sensitive, essentially, all right? And they can require that you abstain from drinking alcohol or taking drugs, including cannabis, on your off hours, all right? So not when you're working, but when you're off work, to ensure that when you arrive to work, you are not impaired, essentially. And they justify this by saying, well, we're a safety sensitive position. We need our staff to be clear minded, because something can go wrong very quickly here. You can imagine other scenarios where the position is not safety sensitive at all. If you work in an office, right, there's no real risk that you're going to run someone over with your bulldozer because you don't drive one. There's not a risk that the crane will fall over because you aren't paying attention. So it really depends a little bit on the workplace itself, but the reality is things have become easier now that cannabis is legal for people to use it recreationally. But if you're in a safety sensitive position, it's important that you be careful, all right? That you review whether your employer has a drug and alcohol policy, and that you ask questions if you're trying to inquire when it's safe to use drugs and alcohol during your off hours. All right. Now, if you're found to be, have consumed the drugs or alcohol at some point during your off time, but still to be impaired during work hours, and this results in either they're suspecting that you're under the influence, or results in you being in an accident, they might do some drug or alcohol testing. And if there is a finding that you were impaired, could result in discipline up to and including termination. Now, that said, it's never that simple. Being terminated for cause is something that's hard to prove, especially when it relates to drugs and alcohol use. Unfortunately, there's a lot of Canadians out there who misuse drug and alcohol and have potentially an addiction to it. And addiction is a protected ground of discrimination, which means you can't be discriminated against because of an addiction, which falls under the rubric of disability under the Human Rights Act. So if you're struggling with addiction to drugs or alcohol and you're terminated as a result, it could be that you're actually entitled to human rights damages, because the first thing the employer should have done is inquire as to whether you need some sort of rehabilitation. Now, of course, not everyone that consumes drugs and alcohol has an addiction, right? But so if you don't have an addiction, you should really try to comply with the drug and alcohol policy you have at work. And if you do find that you're struggling with your use of drugs or alcohol, then you should seek out help and inform your employer that you're struggling with this. You need to find some help to get over this addiction so that you can continue to work safely in the workplace. Now we have an email question here from Terry. Terry asks, I've been working for my employer for 5 years and I have not been allowed to take any vacation. My employer has not paid me out and is still not allowing me to take time off. Is there anything that I can do about this? So absolutely, Terry. Depending on the province that you're living in, the first thing would be to reach out to the Ministry of Labor. So the Ministry of Labor in BC, Alberta, and Ontario have what's called an employment standards branch. And again, employment standards refers to the employment standards legislation that are in all three provinces that allow you to have employee rights at work, such as, minimum vacation pay, statutory holiday pay, overtime pay, all of that. And these rights are enforced by the Ministry of Labor. So you can make a complaint to the Ministry of Labor and basically tell them what you've just told me. Is like, I've been working for 5 years. I haven't been allowed to take time off, and I haven't been paid my vacation pay that I would be entitled to receive. So now what the Employment Standards branch of the Ministry of Labor is going to do is reach out to the employer and, ask, what gives? How come, Terry hasn't received his vacation pay in 5 years? And the employer will then be required to pay you at least the vacation pay. All right. They might ask that you take the time off, but you don't necessarily have to agree to that. If you have, 5 years of vacation, that's between 10 and 15 weeks probably of minimum vacation that you're owed. you don't necessarily want to take that, in November, which is not the most pleasant month in any case. So you can say, well, no, this needs to be paid out to me now. I'll be taking vacation going forward, but right now I want you to pay me in a lump sum the vacation pay that I've accrued over these 5 years. So definitely, that's, as I was saying earlier in the show, that's something that's unacceptable, that an employer holds on to your vacation pay for 5 years, refuses to allow you to take the time, and refuses to pay it out. That's not allowed. That vacation pay belongs to you. They're holding it for you, but that's your money. So you can ask for it whenever you want. So Terry, I mean, if you want to try the simplest route, it's basically to start by telling your employer, listen, I'm owed all this vacation pay that you've been collecting. Pay it to me. Otherwise, I'll go to the Ministry of Labor. And if they don't pay it to you, then go to the Ministry of Labor. And if you want our help in approaching the Ministry of Labor, we're always happy to help as well. Just reach out to us, and you can reach and we can give you more information on how to proceed with the Ministry of Labor. So thank you all for tuning in. My name once again is Lluc Cerda. I'm a senior associate here at the Calgary office of Samfiru, Tumarkin LLP. I am the managing associate here in Calgary, and I'm here to answer your questions live. Any questions related to employment law. We also have a lot of information on our website. Amongst other things, I haven't mentioned it today yet, but I want to always put that in there for those of you who are curious. We talk a lot about severance. And I was saying at the start of the show that severance is different from person to person. So you might, speak to your neighbor who told you they were able to get 10 months of severance. You might speak to your friend who said they got 5, and you don't know what the difference is. We actually have a severance pay calculator online on our website. You just visit pocketemploymentlawyer.ca. You have the URL here on the screen. You answer 4 easy questions, and we will let you know how much severance we think you're entitled to. All right. So a lot of employees don't know exactly how much we're talking about. It can be up to 2 years of salary. Actually, I say 2 years of salary. That's actually incorrect. It's 2 years of your total compensation. So not just your base salary, but potentially bonuses, benefits, car allowance, vacation pay. All these things form part of your severance package. So potentially a lot of money on the line. So do consider it, especially as I said, as we're entering into tumultuous times. This money is not there necessarily as a gift or as some sort of termination bonus to reward you for your long service. It's really there to help you weather the storm. If you get terminated, to help you have some sort of income so that you can find your new job and pick a job that's right for you, not take the first thing that becomes available, not be thrust onto EI or onto, workers, Ontario Works or welfare or things of that nature. So visit our site if you have any questions related to employment law. I have my colleague Jeremy Herman here tomorrow to answer any other questions that arise from now till then. So feel free to tune in. Jeremy will be here at 1:30 Eastern Standard Time, and we'll be happy to take any questions that you have. I thank you all who joined us today, and I hope to see you soon. Thank you, and goodbye.